Most of what an officer says to you at the side of a road costs you nothing. One sentence costs you money immediately. Whether or not you have done anything wrong, we are seizing the vehicle. And from the moment those words leave his mouth, there is a meter running that does not stop for your explanation, your paperwork, or the fact that you turn out to have been entirely right all along. In most provinces in Canada, the towing fee for a seized vehicle runs between $200 and $400, depending on the province, the towing operator, and the time of day. Because after-hours rates exist and they apply, daily storage charges at an impound lot typically run between $20 and $50 per day, again, depending on the province and the facility. And those storage charges usually run from the first business day after seizure, not from the moment the truck pulls away, which sounds like a mercy until you realize that a Friday night seizure sits over a full weekend before the clock technically starts on Monday morning, while the fees at the lot run continuously. And here is the part that fills comment sections with the same words over and over from people it has already happened to. You can pay every dollar of that having done nothing wrong at all. Tonight, I am going to cover what happens in the 90 seconds before the vehicle leaves and what you must do in those 90 seconds because it is free and almost everything after it costs money, what you have to produce to get it back. The timelines nobody mentions at the roadside, and the honest answer to the question everybody actually wants, which is whether any of that money ever comes back. My name is James Hale. I am a criminal defense lawyer in Canada. This is general information about Canadian law. It is not legal advice, and I am not your lawyer. Vehicle seizure law in Canada operates primarily through provincial legislation, and the specifics vary meaningfully by province. So what I say here is general, and you need to know the rules for your specific province. Let me tell you where this video came from, because it was the same question from dozens of people in different words. You are stranded at the roadside at night, miles from home. The vehicle is on the truck. You paid to get home. You paid to get to the impound lot. You paid to get the vehicle back. You had insurance the entire time. How is this legal? And if you were insured all along, does any of that money come back? Those are real questions from real people, and I have never properly answered the part that comes after the stop. So that is tonight. First, the powers. In Canada, police have authority to seize and impound vehicles under multiple different legal frameworks, and the applicable one depends on why the vehicle is being seized. This matters because the procedure, the timelines, and your options differ depending on which power is being used. The most common situation for an ordinary driver is a roadside seizure under provincial highway traffic legislation. Every province has its own version. In Ontario, Section 55.1 of the Highway Traffic Act allows a police officer to impound a vehicle for 7 days where the driver is suspended. Section 172 allows impoundment for street racing and stunt driving. Sections dealing with uninsured operation authorize seizure and impoundment in specific circumstances. British Columbia's Motor Vehicle Act, Alberta's Traffic Safety Act, and the equivalent legislation in every other province contain parallel powers. The key point is that the triggering condition, the thing that justifies the seizure, is defined in the statute, and the officer must have reasonable grounds to believe that condition is met. Under the criminal code, police can also seize vehicles as offense-related property, as proceeds of crime, or as evidence in an investigation. These criminal code powers operate under a different framework than provincial highway traffic seizures. And if your vehicle is being seized under a criminal code power, the situation is more legally complex and you need a lawyer involved immediately. For most ordinary drivers, it is the provincial highway traffic seizure that applies. And in most provinces, there is a procedural step before the vehicle goes. The officer is required to inform you that the vehicle is being seized and the reason for it. In Ontario and most other provinces, this takes the form of a seizure notice, a written document the officer must provide you that contains the reason for the seizure, the location of the impound facility, and the procedure for getting the vehicle back. Ask for that notice before the truck leaves. Get it in your hands. Photograph it if you can, because that piece of paper tells you where to go, what to bring, and how long you have. A seizure notice handed to someone stranded at the side of a road at 11 at night in the rain is a piece of paper that gets lost. Now the 90 seconds. This is the window that matters, because everything you do in it is free, and almost everything that comes after it is not. 1. If the basis for the seizure is something you can address immediately, address it immediately. If the officer says the vehicle is being seized because you cannot produce proof of insurance, and you have the certificate on your phone or in the glove box or accessible through your insurer's app, produce it now. A screenshot is not a legal document in the same way a certificate is, but it is a reason for the officer to pause and check before calling the truck. Many seizures that could have happened did not because someone found the document in time. Many seizures that did happen were entirely avoidable for the same reason. 2, take your documents out of the vehicle before it leaves. Your ownership documents, the vehicle registration if it is in the glove box, your driver's license if you need the physical card, anything with your name and the vehicle's identifying information on it. You are going to need to prove ownership to get the vehicle back. And proving ownership from your kitchen table is considerably easier than proving it when everything relevant is inside an impound lot you cannot enter. 3, take what you actually need for tonight. Your medication, your glasses, your house keys, which people often forget are on the same ring as the car key. Any children who are in the vehicle, obviously. Any animal. Anything that cannot wait until business hours at an impound lot. What you should not do is start emptying the boot onto the road while the officer waits. Take what matters calmly. Leave what can be retrieved later. 4, and this takes about 15 seconds, photograph the vehicle before it goes on the truck. All 4 corners, the current mileage on the dashboard, any existing damage visible on the body. The vehicle is going into a lot operated by a private towing company, and it may sit there for days. If it comes back with a scrape that was not there before, the only person who has a before photograph is you. And 5, ask the officer which towing company has the vehicle and which impound facility it is going to, and write it down or note it on your phone. The seizure notice should contain this information, but not all seizure notices are completed fully at the roadside, and having the information independently is worth the 30 seconds. The sentence that handles all of this at once, said calmly the moment you hear we are seizing the vehicle. Before it goes, can I take my documents, my keys, and my medication out of the car? And can you tell me which impound facility it is going to? That sentence changes nothing about whether the vehicle goes. It changes whether you spend the next week proving ownership of a vehicle you cannot access the paperwork for. Now, the money, and these are not invented numbers or estimates, they are the reality of what impound lots charge in Canada, which varies by province and by operator. because private towing companies set storage rates within a framework that differs across jurisdictions. In Ontario, the towing and impound regime under the Highway Traffic Act involves regulated rates. The Ministry of Transportation sets maximum rates that towing operators can charge for a vehicle inspection order tow, currently in the range of $175 to $225, depending on the type of vehicle. Storage rates are regulated at a maximum daily rate that the ministry updates periodically, currently in the range of $20 to $35 per day, depending on vehicle type. In British Columbia, similar rate regulation exists under the Motor Vehicle Act and the Towing Act. In Alberta, rates are less tightly regulated, and towing companies have more pricing flexibility, which means a seized vehicle in Alberta can face considerably higher daily storage charges than the same vehicle in Ontario. What is consistent across every province is this: the towing fee applies from the moment the vehicle is loaded onto the truck. Storage fees apply from the first chargeable day, which is usually defined in the provincial framework as the first day after seizure, on which the impound lot is open and available for vehicle retrieval. But the fees continue accumulating for every day after that, regardless of whether you know what you need to bring, regardless of whether you were able to find the certificate, and regardless of whether the impound lot was answering its phone when you called that morning. A vehicle seized on a Friday afternoon and not retrieved until the following Tuesday will have 4 to 5 days of storage fees stacked on top of the tow, and that arithmetic moves quickly. At $35 a day, 5 days of storage is $175 on top of the $200 tow before you have addressed whatever underlying issue caused the seizure. Every day you spend being right in slow motion costs you another day. The strategy is not legal cleverness. It is speed. Get the vehicle out as soon as the mandatory hold period expires and you have the documentation ready. The timelines. And in my experience, nobody standing at the side of the road hears these clearly, which is why I am stating them precisely. Under provincial highway traffic legislation, the mandatory impound period depends on the reason for seizure. For a suspension seizure in Ontario, the mandatory impound period is 7 days, and the vehicle cannot be released before that period expires, regardless of what documentation you produce. For a stunt driving seizure in Ontario, the mandatory impound period is 14 days for a first offense and 45 days for a subsequent one. These mandatory periods mean storage fees are accumulating during a window when you cannot retrieve the vehicle even if you want to. After the mandatory period expires, you must attend the impound facility within a defined window, which varies by province and by the type of seizure, to retrieve the vehicle, or it may be eligible for disposal by the lot operator. In British Columbia, similar mandatory hold periods exist for various seizure types, and the province operates a vehicle impound program with its own specific procedures and timelines. Other provinces have comparable frameworks. The 14-day clock, I want you to hear clearly, because it is the one people miss. In most provinces, if you fail to claim a vehicle within a prescribed period after the mandatory hold has expired, the impound operator may apply to have the vehicle declared abandoned and sold. That period varies by province, but it is not indefinitely long. The point is that the vehicle does not sit waiting for you to get around to it. The clock starts and it runs, regardless of whether anyone tells you clearly at the roadside how much time you have. What do you need to bring to get it back? 3 things, and people consistently turn up with 2 of them. Your driver's license, valid for the class of vehicle, proof of insurance, a current insurance certificate showing that the vehicle is insured and that you are authorized to operate it, and proof of ownership, the vehicle permit or registration, a bill of sale, or other documentation connecting you to the vehicle as owner. The insurance requirement catches people who do exactly what sounds sensible. If you did not have insurance at the time of seizure and you buy coverage now to retrieve the vehicle, the certificate you produce must actually permit the release of a vehicle that was impounded. Some short-term or temporary insurance products specifically exclude coverage for impounded vehicles, meaning someone who buys a week of coverage on their phone and drives to the lot can be turned away at the counter having spent the money. Check the specific wording of whatever policy you obtain before you go. The insurance certificate is required even if you are not planning to drive the vehicle away. Even if a friend or a towing service is coming to take it on a flatbed, most provinces require proof of insurance as a condition of release. The condition attaches to the release of the vehicle, not to whether you intend to drive it. And now the question that produced this video, and I am going to answer it honestly rather than comfortably. The vehicle was insured the whole time. I produced the certificate the next day and they released it. Do I get the towing fee and the storage back? The honest answer is that there is no general automatic right to a refund of impound fees in Canada when a vehicle turns out to have been lawfully insured at the time of seizure. The Provincial Highway Traffic Acts do not, in most provinces, contain a provision that automatically triggers a fee refund on proof that the seizure was mistaken. That is not me telling you there is no route. It is me telling you I will not invent one and have people act on it. What actually exists? First, file a written complaint with the police service that conducted the seizure, setting out the facts clearly and attaching the evidence that the vehicle was insured at the time. Police services have complaint processes and they are required to respond. A written complaint creates a record and sometimes produces a result that a phone call does not. Document everything in writing rather than relying on conversations. Second, if the seizure was conducted without the proper legal authority or the officer did not have the reasonable grounds required under the applicable statute, that is a different matter. Section 241 of the Canadian Charter of Rights and Freedoms allows a court to grant a remedy it considers appropriate and just in the circumstances for a breach of charter rights. An unlawful seizure of a vehicle is a potential Section 8 charter breach. Depending on the circumstances, damages may be an available remedy under Section 241. The Supreme Court of Canada confirmed in Vancouver City v. Ward 2010 that damages under Section 241 are available for proven charter breaches where other remedies are not adequate, and that the court assesses the appropriate remedy by considering the seriousness of the breach, whether damages are functionally necessary to vindicate the right, and whether the good governance concern weighs against them in the specific circumstances. This is not a simple or guaranteed path. It requires a lawyer, and it requires establishing that there was, in fact, a charter breach. But it is a real remedy that exists in Canadian law, not a theoretical one. Third, if the sum is significant, an hour with a lawyer who does police oversight work is worth the money to understand your specific options in your province, because the applicable legislation and the available complaint bodies differ, and the right path depends on which province you are in and which police service was involved. What I am not going to do is promise you the money comes back, because a great many people will watch this video while several $100s down, and I would rather be useful than comforting. Here is the part worth understanding about why this happens to insured drivers in the first place. Because it is not usually carelessness, and it is not usually the officer being unreasonable. The license plate recognition camera on the patrol vehicle does not read your insurance policy. It reads your plate and checks that plate against a central database of insured vehicles. What gets flagged is not this person is uninsured. It is this plate is not currently showing as insured in the record I have access to. And there's a long list of entirely lawful situations that produce exactly that result. A policy that started this morning, a vehicle purchased on a Saturday and stopped on a Sunday, a policy renewal that had a one-day gap and was corrected, a change of vehicle mid-policy, an insurer that has not transmitted the update to the central database yet. The database can be out of date while you are entirely insured, and the officer looking at a negative result on his system is not being unreasonable to believe it, which gives you the one genuinely preventative habit in this video. If you have just bought a vehicle, just changed vehicles under an existing policy, or just started a new policy, keep the insurance certificate or the insurer's confirmation email accessible and producible in 30 seconds. The first 2 weeks of any new or changed policy is when the central database is least likely to have caught up with reality. Be ready for the question before you need to answer it. The situation I get asked about constantly, because it happens more often than the simple version. The vehicle is yours, but someone else was driving it. Your son borrowed it, a friend drove it home. Someone was insured on their own policy for their own vehicle, but not for yours, and thought they were or did not think about it at all. The vehicle is now on the truck, and it is registered to you. The uncomfortable answer is that in most provincial highway traffic frameworks, the power to seize attaches to the vehicle being operated contrary to the applicable law, not to whose fault that was. Your innocence as the registered owner does not keep the vehicle out of the lot. You are the one who goes to retrieve it with your license, your insurance, and your proof of ownership. You are the one out of pocket. Whatever conversation you have with the person who is driving comes after, which is an argument for a boring conversation before it ever happens. Anyone who borrows your vehicle should be able to tell you specifically which policy covers them for it. And I am insured to drive any car is a statement worth verifying before you accept it. Many insurance policies that previously included that coverage no longer do, or include it in more limited circumstances than the person believes. One practical point I want to add that no one mentions at the roadside. When you are standing there without your vehicle, you need a way home. I could not find any provision in Canadian law that requires a police officer to arrange transportation for you when a vehicle is seized. Many officers will help. Some will wait with you. Some have helped people get to a station or contact family. That is decency rather than a legal obligation. And I am not going to tell you it is an entitlement when I cannot show you where it is written. The practical preparation is boring, but it costs nothing to do tonight. Have a taxi or rideshare app on your phone. Have a breakdown assistance number that includes transportation coverage. Know whether your existing insurance or roadside assistance plan covers getting you home from a location where your vehicle is not. And keep enough available on a card to get somewhere warm. And the line not to cross. Do not lie about insurance. Do not produce a document that is not genuine. Do not obstruct an officer who is exercising a lawful power. Every one of those turns a bad evening and a bill into a criminal matter. And the criminal matter is by far the more expensive outcome of the two. To bring it together, the sentence at the roadside, the moment you hear we are seizing the vehicle, before it goes, can I take my documents, my keys, and anything I need tonight from the vehicle? And can you tell me which facility it is going to? Take your ownership documents, your medication, your house keys, and anything a person or animal in the vehicle needs tonight. Photograph the vehicle before it goes on the truck. Get the seizure notice and read it. Note the impound facility and the towing company. Go home. Get your insurance certificate and your proof of ownership ready. Call the impound lot first thing in the morning. Understand the mandatory hold period applicable to your situation in your province. And if you believe the seizure was unlawful, contact a lawyer before you spend money on anything else, because your options may be better than they appear right now. Subscribe so you know this before you need it. And if this has already happened to you, leave a comment with what it actually cost you from start to finish, including getting home and getting to the lot. The people who need this next will find your comment before they find any government page.